start this thank you session without referring to you. Rajiv, thank you so much for being here. Several other friends and colleagues from Delhi and across the world. Thank you so much for being here today at this inauguration of the Delhi chapter of the IAF. I think we've heard two fabulous speakers through the evening. I think all our attention has been absolutely riveted to what both of them have said. I think the whole history of the right to arbitrate was indeed absolutely fascinating, Gary. And while one had heard bits and parts of all of this, actually the way you've put it across, I think was very, very fascinating. And I think it gave us a good relief, if I may say so, that Indian law was a bit more progressive than a lot of the other jurisdictions of the world, starting way back in 1872. And Justice Nariman has, of course, taken us through the various problems that we've all grappled with over the years in the field of arbitration. I think a couple of points that he made, I think, are so significant that one cannot but sort of mention them as we do. I think the first would be the whole concept of the seat of the arbitration that he has mentioned. Even though there is, I think, reasonable clarity in the case law that has evolved as to the distinction between seat and venue, we still find our courts interfering, even which is in the middle of an arbitration process by way of Section 9, in spite of the fact that it's been held that Section 9 cannot lie. You have observations, you have findings, giving findings as to what should be the seat of the arbitration, not leaving it to the tribunal itself to decide seat of the arbitration. Interim orders, of course, has been an issue, and with BALCO, we still need to think, who are we advising as lawyers? Are we advising Indian clients? Are we advising foreign clients as to where should be the seat of the arbitration, right from the time when the contracts are being negotiated? I think a very important point that Justice Nariman just mentioned was that of institutional arbitration. I think that's a very, very fundamental point. We've seen over the years just ad hoc arbitrations in India, and that has essentially been, the parties feel they have more control of the arbitrations, not realizing that at the end, those awards get set aside far more than if it were an institutional arbitration. But the challenge that parties have faced, and we as lawyers have faced, is equally the fact that the very few efficiently run and well-managed institutions that can conduct arbitrations in India. I mean, I can't think of one good arbitration center that I would want to refer something to, except a few years ago we started the LCIA India chapter. So I think we need certainly a lot more domestic institutions which can actually do that. So I think any approach or any policy of the government, or maybe private parties, who can get together and set up institutions that can run arbitration is going to be absolutely critical. I think there is a move recently to have a sort of a privately funded and a privately done institution in Maharashtra. And I'm just hoping that with the help of people who are really interested in setting it up, something like that would actually take off and set an example, for many other institutions to actually buckle up and run them more efficiently. I think they could take an example from SIAC. I was among the first directors of SIAC when the board was internationalized, and we saw the progress that SIAC has made over the years. I think we have a lot to learn from best practices. And I think as part of the IAF, which is an arbitration forum of the arbitration bar, I think for any arbitration to be successful, I think there are various stakeholders in this whole process of arbitration, and we as practitioners certainly have a lot to contribute. And I think as members of the Indian Arbitration Bar, we can certainly get together and contribute a whole lot of things. For once, looking at our best practices. At least in the arbitrations that we are all involved in, we can insist on best practices, declarations of independence of arbitrators, which is something so basic and so fundamental, but is not practiced in India. I think starting with something as such, what sort of evidence are we going to lead? I have sat through arbitrations, and I'm sure all of you have sat through arbitrations where the traditional forms of evidence are being conducted, where you put a question or put a statement to the witness and the witness denies the statement. And so the whole case is I put it to you and then the witness denies it. And it just goes endlessly on and on. Those entire techniques of arbitration are outdated. We certainly need to do away with that. The arbitrators themselves need to control the process of arbitration more than we all want them to. Really, they need to do it if we have to promote the whole concept of quick, speedy, and efficiently run arbitrations. Finally, even the awards need to come fast enough. This is a problem not only with domestic awards. We've seen this even in international awards, where they take 6 months, 12 months, 9 months for awards to come, because tribunals or arbitrators are quite busy these days. So I think one more big thing that one challenge that we all face is the lack of infrastructural facilities. And if you look at SIAC or you look anywhere else, you have the ICDR in Fleet Street in London, or you have the whole ICC set up in Paris, or you will have the Maxwell Chambers in Singapore. India lacks one such center where you can go and conduct an arbitration, or you have the facilities where arbitration can be conducted. Arbitrations are conducted in clubs, or they're conducted in 5-star hotels. I don't think that's ideal for the long run. They're not going to be cost efficient at the end of the day, because the amount that is spent on just the infrastructure to set up. The process is tediously slow, because particularly when evidence is being led, because there is no verbatim transcript of what is happening. Some of them have a screen in the front, somebody's typing manually what's happening, and that's the way we progress. So what can take place in 1 day takes 7 days, just because the entire process is manual. So we certainly need a huge amount of infrastructure for the conduct of arbitrations. We need to take arbitration seriously. We also need to stop doing these as part-time. And to that extent, from 4 to 7 in the evening after court hours, I think that is what we as members of the IAF or as the arbitration bar can contribute, certainly. And I think these are some of the challenges that we face, but there is a lot that we ourselves can do to promote the cause of arbitration in India. I think the other challenges that the courts face, and they have dealt with over the years, I think have already been dealt with quite adequately, and I do not want to go through all of those challenges again. But I think if different stakeholders got together and put their minds to what can be done, I'm very confident that we can do what we really need to do, to put India on the map for arbitrations. So finally, I would like to end by thanking Justice Shattar, Justice Khanna, Mr. P.K. Malhotra, our sponsors, Accuracy and Cox and Kings. And really thank you all for being here this evening. You had a long day at the SIAC arbitration and even now, but thank you ever so much for being here this evening. And can I request Ajay to come and felicitate Mr. Gary Vaughan.
Can we also give a gift to Justice Nariman? Yeah, Rajiv.
look like me too much. But brilliant. Thank you.
Ladies and gentlemen, with that we come to the end of our speeches, and since it's Saturday night, you're all invited for cocktails now. Thank you.